Welcome, everybody. We're so excited to have you in class today. Today's topic in class is the Second Amendment. So we're going to dive deep into the constitutional questions around the Second Amendment. And as we do that, we're going to look through American history, try to understand why is it in the Constitution in the first place, and then what was the meaning of it during the Constitution era, as well as the Civil War era, and then modern cases around it today, even ones that are going to be heard by the court in the next year. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center. So I'll be here to help ask lots of questions, and we'd love questions from you. So feel free to put it in the chat or the Q&A. Luckily, I'm not alone in this. I'm here with one of our top scholars, Nicholas Mosvik. Nicholas and I are going to walk through this together. We're going to pepper Nicholas with tons of questions. That was not pun intentional. And we're going to begin, Nicholas. You know I have a million questions about why did they put it in there? How does the Civil War kind of change the meaning of the Second Amendment? And what are the different parts of it? So I know where you like to start, and I think it's a really smart place to start. Let's begin with the actual words of the. And, you know, I have a feeling this is going to turn into an English class really quickly.
Yes. And did you freeze or did I freeze?
You sound good to me.
Okay. Yes. So we start with the two parts of the Second Amendment. So as Curry will show you, we start with what we call the prefatory clause. And so at some point, we're going to figure out exactly when we started referring to it that way, although is when we talk about District of Columbia versus Heller, the 2008 Supreme Court decision, you'll see that that's how the Supreme Court treats the Second Amendment. So prefatory meaning preface is in sort of the opening statement, is it well, right? And that is a well-regulated militia being necessary to the security of the free state. The English lesson is there's a lot of commas here. A well-regulated militia, that's by itself, so we have to define what does that mean. Being necessary to the security of the free state, what does that mean? Then the second part, the operative clause, meaning the idea that this is the substantive right being protected. The right of the people to keep and bear arms, comma, shall not be infringed. So we have a lot of things when you think about the text that we have to answer, right? What is a well-regulated militia? Not just a militia, but what does it mean to be well-regulated? Why is it necessary to the security of a free state? Does that do anything for us? The right of the people to keep and bear arms. So we have to define what is it to keep and bear arms? What are arms? Why do we say the right of the people? And then shall not be infringed. That, of course, is at the beginning, as we talk about with all the Bill of Rights, we're initially referring to Congress. We'll get to why this applies to the states as well when we get to our modern cases. But that just goes to show you there's a lot in here, even in the short piece of text, to be evaluated and understood, right? And the English lesson there, it's a bit of a joke, but it's also to say that's why scholars analyze this and disagree over that. Is so what part of the text is applying to the other parts of the text? If the commas are there, how do we connect the first part to the second part? And as I suggested, it's the Supreme Court in 2008 that says one clause is the prefatory clause and the other is the operative clause, but we can ourselves ask questions and try to answer them about what each piece of this text means.
I love that. And I love that Emily and Karen already got the memo where we sometimes can't always answer yes or no, but we can ask even more questions to pick some of these things apart and understand them more. So Emily's question is, why is arms capitalized? And then Karen had the same kind of thought, but also said, Karen said, but militia is capitalized, which leads one to think it's a formal group. So I love the observation skills and kind of analyzing this as, you know, a constitutional lawyer and a English major as well. And Nicholas, when we come down to the root of the question that's in this class and we look at different time periods, one of the big questions that we have for this class is when can or when may the government limit the individual right to possess guns and other firearms, and when may it not? So that's kind of our framing constitutional question. And we're going to see that question answered in a hypothetical that's in the courts at the end of this. But let's begin in the foundation. Why did they put the Second Amendment in there in the first place? What is it about militia and of the right to bear arms that really wanted to make the founding generation add it to the Constitution in 1791?
Yeah, so I think is we've been doing is the last couple of weeks, we kind of seem to discover as soon as we teach this once exactly kind of what the tread lines are, what is the real story. And that story is kind of, well, what are the things they feared the most at the time that they wrote these things, right? So let's get into that, right? What are some of the fears that are animating writing this? Because remember, we've talked about the Bill of Rights before, and the Bill of Rights is largely a list of these liberties that James Madison puts together in 1789. And the language is based on earlier state constitutions, although the text has changed, and we'll talk about how it's changed. So what was the fears that caused them to write these kind of protections into their state constitutions first? Well, one is standing armies. So we got a picture there that's kind of helpful, the British Army in the colonies. And we did this at noon, and it's worth doing again. Boston is really the big victim of the British standing army first. And Boston in 1774, we're talking about a population of 15,000 to 16,000 people. This is a small city, right? This is not like the European cities. This is an outpost compared to London. And so when the British send 4,000 troops over to Boston, that's one soldier to every 3 to 4 persons in the city. That is a lot, right? So when they think of armed occupation by the British Army, that's what they mean, right? They mean soldiers all over the place taking over the city, and therefore that limits their rights, right? That creates a sort of armed tyranny as opposed to what they think of as the liberty that good government should guarantee. So when they talk about a standing army in peacetime, that's the image, right? The image is the British Army in Boston in 1774. And so that's why they react to it. It's why there are so many of these framers, as we'll talk about, like your Curry's favorite, Elbridge Gerry, are so obsessed with the problem of standing armies. That other piece we showed in the next image is the citizen militia. So what do we mean by that? What is the idea of militia? I mean, militias are an old idea, right? Because sort of the idea of a armed community or populace protecting the order and the people's liberties and rights, right? That's an old concept. And during the Revolutionary War, it's mostly state militias that are fighting, right? There is a national army that George Washington is the head of, but he's mostly getting the troops from the states. It's the states that draft the militia from their body of male citizens and arm them. So the national government isn't arming them. That's why when we talk about Hamilton and Washington complaining they want a stronger national government, one of the complaints comes from their experience during the war of we had to rely on the states for everything. But the states also think of that as a tradition, right? The tradition is we don't have a standing army like the British. We don't have this professional army that brings tyranny. No, we have Republican citizens who view it as their duty, just like being on the jury, right? Part of being a citizen is duties. One of those duties is to be a member of the militia. And therefore, when you're called to arms to defend your community, you do so as part of your duty as a citizen, right? And that goes back to Rome, this idea that democratic citizenship, part of it is these duties, and amongst them is militia membership.
So a couple questions, and I know that like even in this time period, there were like regulations where you did have to have your weapons checked, like as an individual, if you just in case you got called to the militia. But there's a couple of things there that I wanted to kind of parse out, and Anna had a great question. Understanding that we're worried about a standing army as newly formed states. We're worried that this big government army could then be taken over by a dictator, a president that becomes a dictator, and then used against the people, that there would be some way to combat that. But Anna's question is great because she was wondering, does this come into a worry of, what are the checks and balances were put into place so that militias were not used to stage a coup? So what about the flip side of that? You don't have a standing army, and somebody takes over the state militia and tries to overthrow, the barracks or the government and tries to take over, hint,
Yeah.
hint, certain states.
Well, it's a smart question. You'd think the ghost of Alexander Hamilton may have put it there.
Anna
and
Alexander Hamilton.
Yeah, no, I think there's two ways to come at it. One of those is that's why some scholars would read it and say, well, this history of concerns about government tyranny is why this is an individual right, and that individuals ultimately have the right to protect themselves either collectively or as individuals, and it comes from a natural right of self-defense. The other response is that's exactly why Hamilton was looking at the Constitution itself. Article 1, which gives Congress powers to raise and to support an army, to provide for calling forth the militia, to execute the laws of the Union, to suppress insurrections and repel invasions. In other words, should there be something like a rebellion amongst militias and states or something like that, well, that's why Congress has these appropriate powers to organize militia, to call it out, and to raise armies. And Hamilton's point, if you look at the Federalist Papers, is he answers the question about standing armies, and he says, first off, standing armies aren't necessarily bad because all real nations have them to give protection to the people and to therefore protect liberty. He says it's impossible to do that without a ability of Congress to create an army, even if it's a standing army. Because there's Hamilton's saying, well, what about securing our new country? We have people out west, we have borders. It's not just Native Americans. The British are still there, the French are still there, the Spanish are still there. How do we secure a new nation if we don't have an army? We can't just rely on the militia. We know that because we just fought a war and that wasn't enough. So Hamilton very much is drawing from experience and saying, we've been there under the Articles of Confederation. It was a failure, and that's why we have more power. So we shouldn't be worried about standing armies. We should be worried about giving enough power to the national government to protect liberty, because that would be kind of the answer, right? Is no, you have to look at it the other way, right? Okay, anti-federalists are the one who's saying, but standing armies. And that's Hamilton's response. Yes, you've got George Mason there and saying, hey, the danger of standing armies, the danger of civilians no longer controlling the military, that division between the two, they thought that was really important. Some of the state provisions, the state constitutions, including George Mason's and Virginia, specified this, right? And said, yeah, we're talking about denying standing armies in times of peace and maintaining civilian control of the military and protecting militias, as well as this idea of a right to bear arms, which is to say, states disagreed. So if you go look at those states' constitutions, if they made mention of this right, some said, we're talking about individual rights in this militia right. Others were more on the side of talking about the militia and standing armies and limitations on power, right? So in other words, they constructed it differently. And I know, Curry, you pointed out at noon, Pennsylvania even changed in 1790. They rewrote their constitution just before the Bill of Rights were ratified, and they specified that includes like hunting rifles, right? So there's a live debate, in other words,
Yeah,
while this language is being written.
So 1791, the Bill of Rights is added with the Second Amendment, and it
Yep.
is put in and clarified by state constitutions about what do they mean, who can own a rifle or a gun. But the real point of it is that they are worried. They're worried about self-defense, and they are worried about a government getting too big and not having a way to defend it. So it's put in there in 1791. And then we flash forward to 1865. How does this, establishment of state militias, a national army, not having a national army, and individual rights kind of play out around the Second Amendment during the Civil War and at the end after the Civil War is over?
Yeah, so I mean, the big thing before the Civil War, we are involved in some significant conflicts. There's the War of 1812. There's the Mexican-American War. There are other conflicts, including those with Native Americans, like the First and Second Choctaw War. Sorry. Um, so it's not like we don't have conflicts. The difference is there's a pretty small national army, right? There's a pretty small professional army. Most of these wars are fought either by militias, in case of the War of 1812, or volunteers who joined the army, like in the Mexican-American War. We had a bunch of volunteers who joined, war ended, and the army shrank again. And that's what usually happened before the Civil War. Is it would go up for a little bit. State militias would get called out. Sometimes they'd be pretty ineffective, and but it would change after. Yes, I'm sorry, you meant the Seminole War, yeah. The Black Hawk War, that's in 1832. That's in Illinois. So that's the point is there's a lot of those conflicts, but usually those are fought. Some of those were fought locally or by other armies that were raised. You could talk about Andrew Jackson. But yes, in any case, I didn't mean to confuse. I just meant to point out that it's not like we don't have conflicts. We just don't typically have a large national army, especially for long periods of time. What changes during the Civil War is the scale of the war itself, right? We're talking about at least 750,000 people dying, if not more. We're talking about millions of people in the army. And therefore, the old system breaks down, right? Initially, it's Lincoln's calling for volunteers. And first it's 90-day volunteers, and then it's 3 years volunteers. So they try to use volunteers. They try to use the state militias where they can, but that breaks down over time. And eventually by 1863, the war has gone poorly enough that the Republicans support a national draft. And that's not just to force people into the army, that's also to try to get them to volunteer by taking the bounty, which is to say the $400 offered to substitutes. And that largely does work. There are complaints from those who say it's unconstitutional. And one of those complaints, and we see this in court cases, is that the Second Amendment doesn't allow the national government to directly draft individuals because that would destroy the state militias. It would bypass them. In other words, Congress can call out the state militia, but it can't directly grab people.
So Nicholas, just so as we're thinking about this, and this really probably a lot of this starts to happen after the Civil War is over. How do we start to see the effects of the Union troops in the South? And I love this image, and you were talking about it last time, and how the Union troops play a role in the South in ensuring freedoms, but then getting to what happens once the Union troop leaves. And again, thinking about what's our conversation around the Second Amendment directly and how it starts to play out differently in the South, in particularly after the Union troops leave the South.
Well, we're thinking about so what I've been talking about is the way that the image of the militia changes, right? So there are people who are saying, this is too much change, this isn't constitutional, we had this old system we had forever, we should maintain that tradition. So the Civil War itself changes that, right? Because the national army is required and wins the war. It's not the militia that does so. And that afterwards, that same national army that holds together the victory of the war, right? Because if the war has any meaning, it has to have changed something, right? Slavery has to be abolished, and that has to have some sort of meaningful end result. And it's the national army that is going into the South. That's military reconstruction starting in 1867. And when we say that, we mean that the US military goes into several southern states, former Confederate states, and they help to draft new constitutions, to elect biracial legislators, and to ensure civil rights. The presence of the army does that. So the point there is that the army is now the vehicle of freedom, and they were during the war, right? It's the Emancipation Proclamation means that slave persons run to the army for freedom. That's the idea, is come to the army will guarantee your freedom, right? So the national army itself, both during the Civil War and Reconstruction, is now the vehicle of freedom, and it's the militias, both state and private militias that become the image of tyranny. So unlike 1791, where it's the national government might well bring tyranny and we need to be protected by that, the state institutions will protect us. Now we're worried that the states are actually creating tyranny. And sometimes it's because they're protecting private militias like the Ku Klux Klan that are bringing down terrorism in the South. So that's what
Perfect.
it is, I think, right?
Yeah, I think that's really interesting because and I love that you can look at imagery from the revolutionary time period where you see, the individual fighting up against this big national government that is dangerous, or the British before that, and it flips. And now we see the individual being protected by the national government, but also in a way have protect themselves against others. And some of those others being the state militia. I think, it sums up in Ida B. Wells' quote here the most. And in Nicholas, I can turn it back to you at this point to kind of like walk us through kind of what's the perspective that Ida B. Wells is trying to share about the relationship between liberty and, your bodily safety and being alive, and individual rights to self-defense.
I think it does go back to the assertion of this, like a natural right to self-defense, in the sense that ultimately the Second Amendment, or the right to keep and bear arms, has something to do with the inherent right of individuals to protect themselves against threat. And that's something that abolitionists talked about before the Civil War, right? Because to run the Underground Railroad was to be under threat of death. To advocate for abolition was to be under threat of death, right? And so many of them talked about the need to protect themselves, right? Harriet Tubman famously carried arms herself. And as we talked about at the noon hour, right, Curry, I mean, this is why even some states started limiting guns and carry, because they were worried about the threat and the outbreak of violence, even in DC, amongst politicians who threatened a duel over the issue of slavery. And then it's Frederick Douglass, and then later Ida B. Wells. I think they're talking about the same thing, which is we need this guarantee because the threats come both from government and from other individuals, and sometimes government protects those individuals who do this, right? And that's the state problem. And that's why in the Civil Rights Act of 1866, you saw the right to keep and bear arms amongst the listed basic civil rights that the government would protect. And so when you talk about the 14th Amendment, there's this notion that some scholars talk about that that's why the Second Amendment is amongst those that's not only incorporated against the states, but perhaps it changes what we're thinking about, right? Now we are thinking about this protecting this right of individuals to defend themselves and to bear arms, and that African Americans had previously been denied that, because even if you look at some of the pre-war limitations on gun owning, some of the states were discriminatory laws that fear was African Americans can't hold guns any more than they can be on a jury.
And I think that's a really good thing to point out. And just like any other amendment, there are rights that are defined by the amendment, but there are always limitations around that right at the same time. And sometimes these limitations were based in race judgments and saying you cannot have it because you are of this race or you're a female. There's always been limitations around it. I point up the Colfax Massacre, and we talked about this a lot in previous classes, but if you don't know the case, students, and we can send it to you, it's Crookshank. So there's the Colfax Massacre, where hundreds of African Americans are killed by a group of angry white mob. It's a bloody massacre, and it goes to the Supreme Court. 9 people are indicted and convicted on the lower courts. It goes to the Supreme Court, and the Supreme Court says, the 14th Amendment only applies to state action, not in individual actions. So it goes back to Ida B. Wells. The reason why we bring it up, it goes back to Ida B. Wells and saying, well, if the state's not going to protect us, then we have to protect ourselves.
But it's not the only thing, Curry. It also says the Bill of Rights don't apply to the states.
So
at least in that case.
Yes, in that case. And that brings us perfectly,
so
thank you, Nicholas, So when does the Second Amendment start to apply to the states? And so I figured that tees up really nicely to Heller.
Yeah, and I think one thing we also got to there is to keep in mind when you ask that question about what is reasonable regulation or what can be regulated, the regulation doesn't always go one way, right? It's not one direction. So that means in the 19th century, some of that state regulation was discriminatory, and that's its own question, right? Is can you know, what would be arbitrary or unreasonable regulation can look a lot of different ways. And that can take us to some of these stories, right? So District of Columbia versus Heller. Big thing to keep in mind here is that DC is ultimately under the control of Congress because it's the seat of the government under the Constitution. Therefore, the decision didn't apply to states. And the question here was, could DC essentially ban handguns within the district, right? The question here for Mr. Heller and his team of lawyers, one of those, Clark Neely, Clark is on the right here. He will be talking to our class Friday about the Second Amendment, was, okay, does the Second Amendment protect the right of individuals to carry a hand or to have a handgun within the home, right? And the Supreme Court 5-4 said, yes, it does. Justice Scalia wrote the opinion. What he found here was, yes, it protects this individual right. We had, as we talked about at the beginning, the prefatory clause and the operatory clause. And Justice Scalia says, look, in this, this right is subject to reasonable regulation outside the home. So that can mean a lot of, basically what he meant is existing laws were not necessarily being struck down by this decision, just this DC law in particular, in that, at least to the federal government, you couldn't have a law that completely denied the right of individuals to own a handgun within the home, what we would call a categorical law. And so he was clear about that, and that the militia clause did not limit the individual right, and that ultimately what the Constitution did in the Second Amendment was to protect a pre-existing right of self-defense and to keep and bear arms that went back to the English Bill of Rights of 1689. We haven't talked about that yet, but there it says that the subjects which are Protestants may have arms for the defense suitable to their conditions and is allowed by law, which does suggest, again, reasonable regulation. What is that? It's also interesting that it says Protestants. That's a reminder that religious warfare was rather important to understanding the English in the 17th century. So that's what Scalia says, which tells us we still have to figure out what reasonable regulation means. We're still fighting about that. There is a dissent, of course. That's Justice John Paul Stevens. We have a quote there, right, who's saying, no, you have to read the militia clause. That actually does a lot of work here. If you look at the Virginia proposals during the convention and the Bill of Rights, it's revealing, right? Because we're talking about protecting civilian uses, rejecting a formulation that would have protected civilian uses of firearms. What Stevens was saying is the drafts changed in 1789 for the Bill of Rights. There were state constitutions, there were the states that proposed a Bill of Rights, like Pennsylvania, that included language referring to individual rights. There was language referring to standing armies as well. All of that was lost by the Senate. And so what Stevens was saying is we should assume that the remaining language didn't necessarily do this. It was about something else, namely federalism, right? Defending the state power over the militias versus national power over the militia.
Got it. Okay, Nicholas, real quick, we're going to do
we're talking about
McDonald. Yeah.
Yeah, we're talking about incorporation here, meaning applying Heller, the rule of Heller, to state laws, into here the city of Chicago, so that could also be local laws as well. And why is it incorporated? So it's a 5-4 decision again, where the majority is saying this is a essential or fundamental right? It's deeply rooted in our history, and therefore it applies to the states. Chicago, no different than DC, cannot categorically not allow its citizens to own guns within the home. So again, it's not answering that other question of what do we mean by reasonable regulation, which I really think leads us to the end, because that's kind of the last 10 years or so.
Yeah. So, and that's exactly where, the students are asking questions about where's this balance. And Linda pointed out, it's not just for safety, hunting's involved in this as well. It gets us on a side tangent about Dick Cheney and hunting, but the real question comes from Ellen. Can we discuss states trying to pass a constitutional carry amendment? So I think that leads us nicely to the hypothetical. And students, as always with hypotheticals, yes, no, maybe, or I'm not sure right now, because we have so many questions about this constitutional question that's going to be heard in the next year, that we can start by just breaking it down and what do we want to understand more around. So Nicholas, walk us through this hypothetical and then we'll dig into it.
Yes, so the hypothetical is basically the question that the Supreme Court is going to take up this fall in a case out of New York. And so that question is, what if a city or Hawaii, a state like Hawaii or New York says you can't really carry the gun outside of your home unless you can show a special need for self-protection. I like what Curry said at the noon hour too, where she pointed out that even that last component could be a separate constitutional question of due process, because what if it's shown that it's arbitrarily enforced or discriminatorily enforced to figure out by the individual government official who needs special protection and who doesn't, right? So that in of itself is a separate constitutional question. So we do see states that have this, and really the fundamental question is both, does Heller apply to outside the home? Is there a right to carry the handgun outside the home? And therefore the related question is, what is reasonable regulation? In other words, what scrutiny do we apply to state laws? Do we treat it like the First Amendment? And if we do, is it intermediate in the sense that it's like time, manner, and place restrictions? Or is it more like strict scrutiny, where we say in other First Amendment contexts that we really, really look hard at the state laws and many of them would get struck down? Or is it the opposite? Is it rational basis in the sense that we defer to states, and unless it can show that it's unreasonable or arbitrary, any state regulations will be upheld? So I'm just kind of giving the different options, relatively speaking. And that's kind of what we're talking about is, okay, we're now kind of trying to find the place in the balance that the Supreme Court is going to decide between the right of states and localities to regulate handguns and other arms, and that individual right that we found in Heller.
Awesome. This is wonderful. I know some of our students have to jump, and I totally understand, but I am going to do a couple of follow-up questions. I absolutely love the questions in the chat.
So close to 2:30.
Yeah, so close to 2:30, but let's do this. Let's stop share for a second. Let's end the recording.